All right. Good morning.
Morning.
Ms. Stein, you'll be arguing first for the appellant?
Yes, Your Honor.
All right, proceed, please.
May it please the court, Dinah Stein on behalf of the Appellant Pediatrics Medical Group, and I would like to reserve 5 minutes for rebuttal.
All right, you got it.
Thank you. And we're here today on a pure question of law on coverage and a duty to defend, and that is whether this commercial general liability policy that Appellee Wausau issued to the insured covers a common law non-medical tort of arising out of an office worker failing to make contact with a prospective patient. We contend, based on very well-established principles of construction of insurance contracts, that this easily falls under the definitions of coverage and does not fall under the exclusions in the policy. We know, of course, that coverage is to be interpreted broadly in favor of the insured. If there are ambiguities, they are construed in favor of the insured. And if terms are not defined, we go by their common definition. So the real question on coverage is this potentially a covered bodily injury as defined under the policy? And this policy is different than some of the ones cited by Wausau in the briefs in that it defines bodily injury broadly. It is not just a commonly understood injury such as a car accident, but it includes sickness or disease.
But here to find for the appellant, wouldn't we have to define it so it includes being born? Isn't that really what it turns on, that the injury would have to be being born?
No, Your Honor. Well, no, the injury, first of all, we look to what's covered because the policy doesn't say that the, Your Honor asked an interesting question. The policy covers broadly those sums that the insured becomes legally obligated to pay as damages because of a bodily injury. So it doesn't require that the insured cause the injury. Now, as far as being born, that is the underlying injury.
Well, you need an occurrence also, right? What's
correct.
The occurrence?
The occurrence is, again, the policy broadly defines occurrence to include an accident. Accident is not defined. So we look to the Florida Supreme Court construal of the definition of occurrence when accident is not defined, and it's any act of negligence. The occurrence here is where the office worker was asked to get a phone number for Mrs. Ray and failed to make contact with her, causing the inability to terminate the pregnancy.
And that goes back to my point, and therefore the occurrence caused the child to be born. So we would have to define the injury as the child being born.
Well, a child, there'd be no cause of action below if the child was simply born. The whole concept, it's a judicially created concept of wrongful birth, means the child's born with a condition that the parents reasonably would have terminated the pregnancy over. So it's not enough that she's simply born. I don't think that's the injury. I think that she's born with the condition that the parents were unable to diagnose on time is the injury. To just narrow it down to being born, I think just kind of doesn't consider what the cause of action is below. If she was simply born, there'd be no cause of action. She's born with a condition, a sickness or disease, and the policy goes further than that. It includes as a bodily injury, mental anguish. And the mental anguish, it has to be caused by a bodily injury. It does not have to be caused by to the same person who experienced or suffered the bodily injury. See, that's another difference with this policy than the cases that have been cited in the briefs, such as Great American or the Allstate case, where those policies talk about bodily injury, the mental anguish caused by that person's bodily injury.
But I get, my point is, I'm not My point is not whether there is or is not a cause of action here. The question is whether there is coverage under the plain language of the policy. So I think we do have to keep that distinction in mind when we're trying to define terms such as what's the injury that's covered.
Absolutely, Your Honor. Well, then going back to Your Honor's question, isn't it being born? If the child was simply born, that's not the nature of the parents' claims in the underlying complaint. They're not saying that there's an injury because she was born. They're saying she was born with a condition. I mean, that's key to the underlying complaint. Otherwise, Florida wouldn't recognize a cause of action, I don't think, for just, allowing a child to be born. I mean, and in this one, it's not even a medical cause of action. They're saying you prevented us from timely finding out about this condition that she was born with. So again, with coverage and a duty to defend, we look to the underlying complaint, and the complaint is not just that the child was born, it's that she was born with Down syndrome and that this has caused mental anguish to the parents. And again, it's not about, what Wausau thinks should be covered. I mean, this just goes to the plain language. And again, the plain language says bodily injury damages that the insured is legally obligated to pay.
I'm sorry, I think Judge Smith is trying to ask a question.
Oh, I'm sorry, Judge Smith, I see.
My speaker sometimes doesn't pick up. Okay, so
Your mic is too far away.
I might have to get a headset.
Okay.
Okay, so the question that I have, okay, you focused on the Down syndrome part of this, okay, and so my question is, there are two other, and there may be more, but the two that I have down here are, there was also a defect with the heart, and there was also a blood disorder. Were those known before the child was born, or were those known at the time the child was born?
There is no record evidence that that was known before she was born. What is?
So looking at your definition, then, is it your position then that so at the time the child was born, then it was also born with these other injury or disease, being the heart and the blood disorder? Is that how I understand your argument?
Yes, to clarify, the mother testified, this is in the record, she didn't discover the Down syndrome until the child was born. And there's no evidence that they discovered the attendant physical injuries that go with it, beforehand. So I think I'm answering your Honor's question affirmatively, that it was all discovered after she was born, which gave rise to the cause of action. I mean, if she had not been born, we wouldn't be dealing with a wrongful birth case. It would be an entirely different type of case. We're dealing with the type of case that the plaintiffs, the Rays, filed against pediatrics, and that is you wrongfully allowed the birth to happen. A person was born with bodily injury, sickness or disease, which caused mental anguish to the parents.
Let me ask you if we could. I know there's another part of your argument that deals with the exclusions, and I don't want you to run out of time on the exclusions. And there's been some argument in the briefs as to whether or not we should find that the plaintiffs here were not patients. Can you go in and discuss the arguments as far as why the exclusions don't apply here?
Yes, Your Honor, and thank you for that. The record's undisputed that pediatrics, the insured, is a specialty business that treats high-risk perinatal patients. She had the regular OBGYNs that she was being treated with. That's the former defendant who settled out. But they just sent her to a pediatrics group for a referral. The record shows that after the pediatrics group didn't get in touch with her, they didn't make contact with her, they were contacted again. She had one appointment with them on September 9th. This is about 6 weeks or 7 weeks before the child was born. There's absolutely no record evidence, and we've, both sides have had access to the record below. There's no record evidence that she was ever seen more than that one time where she was looked at because she was a high-risk patient, which is what pediatrics group does. And at that point, she was offered amniocentesis, but turned it down because it was too late to terminate the pregnancy. Mrs. Ray's deposition is in the record, and she doesn't even mention, other than that one appointment, pediatrics medical group. So it was a one-time appointment because she was a high-risk patient. And I know that the definition in the exclusion is while someone's the patient. Well, we know that the negligence occurred, the alleged negligence occurred before Mrs. Ray was ever a patient. That's why this isn't a medical tort in the underlying case, because she never became a patient when the negligence occurred. She was a future prospective patient. At the time the child was born, it had been weeks, the relationship had ceased. I mean, this was not an ongoing relationship because she was being treated by Women's Care, which was, again, that was the co-defendant, and they were the ones who attended to her birth. So, that's, and I think that Wausau's tried to create a fact issue out of that. There is no fact issue. It would be in the record somewhere. So that takes us out of the patient injury exclusion. There's just no record evidence that this is a patient injury. And again, this is not being treated as a medical tort below. This is being tried against pediatrics under common law principles, which brings us to the other exclusion, and that's what the court found applied. It's actually two exclusions, the professional services and healthcare provider. And again, that I think can be easily answered. The case law is very instructive on those exclusions. And what the cases show, the cases where that Wausau is relying on, cases like Alpha Therapeutic, like Tinervin, these are cases that show that if someone's doing something within the professional job of the insured, either treating a patient, sending the patient for medical tests, testing blood plasma for antigens, if the negligence happens in the course and scope of that, it is going to be considered a professional tort, a professional negligence, and fall into the exclusion. If you look at the cases we cite, though, they make a very clear distinction for clerical type errors that are not torts. And that is, for instance, Jefferson, the ambulance case that didn't treat the patient on time because it got the address wrong. That was not a professional tort. The lawyer who sent a letter to a prospective client and breached a confidentiality clause, that was not a professional tort.
You're in the 6-minute range, just so you know.
Thank you, Your Honor.
Yeah.
I'll keep talking for a little bit because I think this is an important point. And that is that the allegation is that no healthcare provider at pediatrics treated Mrs. Ray, and which is what the very thing that caused them not to diagnose, or they're claiming diagnose the Down syndrome timely. That is why 2 judges below found that this is not going to go forward as medical negligence, because you cannot have a medical negligence case where there is no patient medical provider doctor relationship. This is simply an issue of a office worker getting a phone number and getting it wrong and not making the correct contact with a prospective patient. So that's undisputed, is that at the time of the alleged negligence, Mrs. Ray was not a patient of pediatrics medical group. She was not receiving treatment. It was not a professional tort. So, and the diagnostic test exclusion, I'd submit, has nothing to do with this. I mean, she wasn't a patient. There was no diagnostic test that went wrong. So again, we don't look to what Wausau thinks is fair or what viscerally should happen. This is based on the plain language of the policy. Wausau issued a policy that covers bodily injury, and if the pediatrics is going to be held liable for bodily injury, there is coverage and at the very least a duty to defend. And I'm probably into my rebuttal time, so I will reserve the rest for rebuttal.
All right, I'll tell you what, I'll round it up. I'll save you 5 minutes.
Thank you, Your Honor.
All right. Mr. Rosen? Your mic is on mute still.
Good morning, Your Honors. Jonathan Rosen from Lappin
Good
and
morning.
Liking on behalf of the Ackerlee Wassa Underwriters Insurance Company. I do agree with my opposing counsel that this case is about the plain language of the policy. I think we have fundamental disagreements about what the policy says and means. This is not, the underlying claim in this case is not a personal injury case. And it's interesting because the coverage action, the claim for coverage, is brought under the bodily injury portion of the policy. Normally, this covers personal injury type claims. This is a wrongful birth action, the underlying action. So the allegation is not that the defendant caused personal injury to anyone. It's that through a series of procedural and communication failures, not just of somebody not making a phone call, but in policies and procedures by a clinic that provides services to high-risk obstetrical patients, that had it not been for those failures, the mother would have received medical information that she was going to have a baby with Down syndrome, and she would have terminated the pregnancy. So, you know, again, there is a series of problems in trying to construe coverage, even before you get to the exclusions under the policy. The first problem is the policy defines bodily injury as bodily injury, sickness, or disease sustained by a person. So even before you get to person, the first problem is the word sustained. And I think the briefs agree on the dictionary, the plain meaning of sustain, the dictionary definition is to suffer or undergo. And there is a temporal component to that definition. In other words, to suffer or undergo a disease, a sickness, or an injury, you have to have, there needs to be a period of time where you didn't have it. In other words, a pre-injury or pre-sickness or pre-disease state. We don't have that here.
Well,
because Down syndrome.
This is a pre-existing condition that the failure to make that notification call to didn't cause the genetic condition, but it did cause them an ability to terminate a condition.
Well, there are actually two different issues here. One is the cause by an occurrence, which I haven't gotten to yet. And you're right, Your Honor, that under the policy, an occurrence has to cause the bodily injury. But before you even get to that issue, there was no bodily injury sustained. Because to sustain an injury, you have to be injury-free before you can sustain it. Before you sustain a disease, you have to be disease-free. Down syndrome is something that the baby, KR, always have. She was born with it. She never existed without it. So under the plain language of the policy, she can't be said to have sustained Down syndrome or sustained a disease or a sickness. This was always part of who she was. It's a genetic disease. It's undisputed in the record that Down syndrome is something that exists before birth, either through the parent's reproductive cells or early in fetal development. It's not something that occurs after birth.
What they're saying is, tell me if I'm wrong, they sustained a birth that they wouldn't have sustained had they not had this occurrence of an improper or failure to make a contact.
Right. The allegation is that they sustained a birth, but not a bodily injury, not a disease.
Bodily injury. Okay, so to opposing counsel's argument, if bodily injury includes mental anguish, how do you respond to that? Sure.
Well, mental anguish is part of bodily injury, but it's mental anguish, shock, or humiliation arising out of, and then it refers back to Part A, which is bodily injury, sickness, or disease sustained by a person. So the mental anguish has to arise out of bodily injury sustained by a person. You have the same problem here. It collapses back into the definition of bodily injury. The mental anguish that the parents suffered arose out of the child being born with Down syndrome, which is not a disease that was sustained, and it wasn't caused by an occurrence either. So for that reason, the mental anguish isn't covered, even setting aside the issue whether it has to be the same person who suffers the bodily injury that experiences the mental anguish. Even assuming opposing counsel is right, and it doesn't have to be the same person, the mental anguish doesn't arise out of bodily injury sustained by a person or caused by an occurrence.
Let me ask you a question, Mr. Rosen. Okay, so and you focused on the disease being the Down syndrome. What about the argument as to the additional defects that the child was born with, the heart condition and the blood disorder? Were those Were those a condition that preceded birth that were known, or does that matter?
Two issues, Your Honor. The deposition testimony from Rebecca Ray indicates that those, and I believe opposing counsel used the word attendant to Down syndrome. These were conditions that were part of and related to the Down syndrome. There's no allegation that there was any testing or information that those particular conditions were shown on any diagnostic test. In other words, if the allegation is that had medical information been provided to the parents that they were going to have a child with Down syndrome, they would have aborted. There's no allegation that these other conditions were part of the information that should have been transmitted to the parents. So I don't know how the insured could be legally obligated to pay for these other damages if there's no causal connection between the failure to effectively communicate and these other conditions. In other words, the allegation is that had we known that we were going to have a baby with Down syndrome, we would have terminated the pregnancy. There isn't an allegation that had we known of these attendant conditions, and if the attendant conditions are just part of Down syndrome, then it's really all part of the same, alleged bodily injury, which isn't really bodily injury because it's a congenital disease. And the other part of that is these conditions were present at birth. So you have the same issues that you do with the Down syndrome. Karina Ray never existed without these conditions. So she didn't sustain them. And they weren't bodily injury caused by an occurrence. They were either part of the Down syndrome, and if they were separate, they still existed at birth. Does that answer your question?
I think so. Thank you.
Thank you. Okay, so the last reason, I'm sorry, the second reason, which I didn't address yet, is that even if you can say that the Down syndrome and these other conditions, whether or not they're part of Down syndrome, were sustained, the Down syndrome was not sustained by a person because Karina Ray was a fetus at the time that she, quote unquote, sustained the Down syndrome, if she can even be said to have sustained it. Under Florida law, it's clear that a fetus is not considered a person in a variety of contexts, including under the Wrongful Death Act, for purposes of construction of the guardianship statute, which defines a ward as a person. And the court in that case, in in re guardianship of DDS, went through Florida law extensively and found there really is no context in which a fetus is considered a person. It's true for the child abuse statute as well. The only cases that the opposition relies on to contend that a fetus is a person under Florida law are the born alive cases. And those don't support the proposition. What those cases hold that if a fetus suffers a prenatal injury and survives to birth and is a person at that point, then they can bring an action in their own right for the injuries they sustained as a fetus. But it doesn't suggest that at the time of the injury, when they're a fetus, they're a person. To the contrary, those cases show that if you don't survive to birth, you have no cause of action as a person. The mother might have a cause of action, but the fetus doesn't have a cause of action as a person. Fetus and persons are treated differently under Florida law. The damages for a wrongful death action for a person are different than the stillborn cases where, and they're governed by different statutes. Again, the born alive cases don't support their proposition. And the last problem, just under the coverage portion of this, is no bodily injury caused by an occurrence. The only occurrence identified by pediatrics is their own negligence. And there's no plausible theory of causation, forget even an allegation, that anything pediatrics did or didn't do would have prevented the Down syndrome. It may have prevented the birth, but not the Down syndrome. And again, to argue that birth is bodily injury under the policy doesn't comport with the plain language of the policy. And I think we've already addressed the mental anguish portion. So unless Your Honor says any additional questions under the coverage portion, I was going to move into the exclusions. No? Okay. So there, and I realized there were some questions about the patient injury exclusion. That was actually never addressed by the trial court. There are three other exclusions that the language don't require that the plaintiff be a patient, to fall under, and that is the healthcare providers, the services furnished by healthcare providers exclusion, the professional services exclusion, and the diagnostic testing laboratory exclusions. We've relied on Florida law in our briefs. The opposition relies heavily on out-of-state law. We think there's no reason to look at the laws of Texas or Massachusetts when you've got fact patterns in Florida that are very close to what we have here. And there are three cases in particular. The first is the Alpha Therapeutic Corporation case from the 11th Circuit. In that case, the professional services exclusion barred coverage for a claim arising out of a transcription error by a technician about blood test results. And as a result, there was blood that was contaminated with hepatitis that wasn't retested and it was sold. Certainly the technician was a non-medical professional, but it was part and parcel of a medical service of testing blood for hepatitis. And there's a very useful quote from the Alpha Therapeutic case. Indeed, most professional services involve clerical duties that may lead to liability. While these duties typically are performed by a secretary or assistant, the professional is ultimately responsible for the duty. In this case, we've got a clinic that provides services to high-risk obstetrical patients. These are patients with time-sensitive medical issues. And there is an element of medical judgment involved when you're developing policies and procedures for communicating not just with the patients themselves, but also with the medical providers that refer them to you. And that is at the heart of the complaint by the Rays in this case, that there were these procedural and policy failures that resulted in Rebecca Ray not getting to her perinatal appointment within time to make the decision, and even more importantly, being deprived of medical and information, advice, and instruction that would have caused her to terminate her pregnancy. That gets you squarely within the professional services exclusion, within the diagnostic lab testing exclusion, which doesn't require, by the way, that the insured be the one that performed the diagnostic test. The claim only makes sense is if had she gotten to her perinatal appointment on time, in time to make the decision to terminate the pregnancy, she would have been told that her baby was likely to be born with Down syndrome and would have terminated the pregnancy. There's no other way to construe the allegations in this case other than falling under the diagnostic lab testing. And again, the exclusion itself doesn't have any language that requires that the insured be the one that actually did the testing. It was the co-defendant, Women's Care, that did it. But the gist of the claim is had she gotten to pediatrics, she would have been informed of those results and would have elected to terminate the pregnancy. The other case that's, I think, factually analogous is the Colony Insurance versus Suncoast Medical. In that case, the allegations were the clinic failed to evaluate and follow up on diagnostic tests on a timely basis and to bring the reported values to the attention of the involved treating physicians, and failed to have in place sufficient policies and procedures, staff, and assistive technology to ensure that diagnostic tests and communication between physicians and other medical personnel was performed. That case involved a liver cancer whose lesion continued to grow in size. And because of these communication breakdowns and policies and procedures that were lacking, he didn't get his treatment on time and ultimately died as a result. And the third case is the estate of Tenervan case, where the doctor's assistant, again, a non-professional, misfiled lab results. Certainly it doesn't take medical judgment or expertise or training to file a lab result, but it's part and parcel of providing the medical service. It's no good to have a brilliant physician interpreting lab results if they're misfiled and they don't get analyzed. Just as in this case, no matter how brilliant the pediatrics physicians were, if she never gets to her appointment in time to get the information she needs to make the decision whether or not to terminate the pregnancy, that is part and parcel of providing medical advice and instruction. And the gist of the claim here is she didn't get that medical advice or instruction on time. There's some other arguments in the brief about pediatrics. I'm sorry, that Wausau is bound by the denial of pediatrics motion to dismiss and motion for summary judgment, which argued that these, in fact, were medical negligence claims. Certainly, Wausau shouldn't be bound by a non-final order. All the cases they cite involve final judgments where the insurer fails to defend wrongfully, and then they're bound by material determinations in those judgments, such as did the insured actually commit negligence? Did the negligence cause the injury? None of that's been decided here. This case is set for trial in February 2022, 21, there's been no determination of liability. There's no final judgment that would bind Wausau as to any issues. And even if you're bound by a final judgment as the insurer, you still get to argue about coverage. And then the other issue is the Chapter 766 cases, the medical negligence cases, don't address, they're not the same issue as construing a policy exclusion, which involves a matter of contractual interpretation. The State Farm versus Campbell case and the Cincinnati Insurance versus Core Management Corporation cases both indicate that Chapter 766 cases should not be used to construe exclusions in a CGL policy. The issues are different, and the exclusions can be construed more broadly. There are a number of reasons to construe the medical malpractice statutes narrowly. They deny access to courts. There's a short statute of limitations. There's a complex pre-suit procedure. None of those issues are attendant when you're construing an insurance policy. And lastly, there was an issue about whether, even if there isn't a patient-physician relationship at the time of the alleged negligence, there's several cases, there's no such limitation in the exclusion. There's no requirement that there be a patient-physician relationship in the professional services exclusion, in the medical services exclusion, or in the diagnostic testing laboratories exclusion. And there are two cases that we cited that address that issue. The St. Paul Fire and Marine Insurance Company case out of the Middle District. And there's a quote from that case. Not relevant is the fact that Mr. Bell was not a patient of Dr. Togart's at the time of his injury, since neither the insurer's coverage language nor the insurer's exclusion is limited to claims brought by patients alleging negligence in the provision of professional services. Here, ultimately, she did become a patient, although apparently too late to get the medical advice or instruction that she needed. And then the other case is the Volgasang versus Allstate case. That case involved a suit against an attorney by the client's ex-wife. There was no attorney-client relationship. The plaintiff was never a client of the attorneys. In fact, it was an adversarial relationship. The claim was nonetheless barred. The coverage was barred by the professional services exclusion in that case, even though the ex-wife was never a client of the attorneys. So it's not necessary that there be a patient-physician relationship for any of the three exclusions that the trial court found applied in this case. I believe that's all I have, Your Honors. If you have any other questions, I'm happy to answer them. Otherwise, I will turn the podium back over to my opposing counsel.
All right, thank you. Ms. Stein, I said I would save you 5 minutes, and that's what I'll give you.
Thank you, Your Honors. And just to go back to counsel's discussions of sustained and mental anguish and sustained by a person, there is nowhere in this policy that puts temporal limitations or aspects on these terms. And Wausau has continuously tried to do that to make its own definition as to what constitutes a bodily injury. Judge Rothstein-Yoakum goes to the birth, is being born the injury. Well, not by the underlying complaint, because the complaint says a lot more than that. And that's what guides this. So there's no temporal aspect to this. Wausau issued a policy to a business that does perinatal consulting to high-risk patients in a jurisdiction that recognizes wrongful birth. It all goes back to the coverage provision, which states its coverage for damages that the insured becomes legally obligated to pay because of bodily injury. It doesn't say when, and it doesn't say who caused it, and it doesn't say that the insured has to cause it. The insured just has to cause whatever theory of negligence makes it liable, legally obligated to pay damages for bodily injury. We have bodily injury, which is defined as it's defined under this policy, sickness, disease, and the other physical defects that are in this record. So again, that's number one. There's just no temporal aspect to this. As far as the child being a person, Florida law recognizes that causes of action exist if a person is born and makes it to term. And in fact, it's a legal fiction. Florida recognizes it, that causes of action can arise even if they couldn't have arisen due to injuries in utero. If the person was not born, if it was a stillbirth, they're going to recognize it as a person under the law as far as tort law. And here, of course, the child is a person. The parents are asserting mental anguish due to the condition with which she was born as a result of what they contend is pediatrics is negligence. As far as, and so again, coverage, they're the ones who defined it this broadly. They're the ones who defined bodily injury. It falls under their coverage. As far as the exclusion, again, just to go back to this, the medical judgment is just not at issue here. That is why this is not being treated as a professional tort in the trial court. And in fact, the cases that talk about the treatment course, they say you can't delegate your treatment. You can't delegate transposing numbers or giving test results to somebody in the office and then say you're not responsible once you start the course of treatment. There was never a course of treatment started here. This was not a professional tort. This is a question of not making contact with a future patient. And finally, as far as Chapter 766, the cases absolutely can be compared. We're not arguing pre-suit. This has nothing to do with the technical aspects of Chapter 66. But the case law, the common law is very telling as far as if it falls under Chapter 6 generally for common law purposes, it's probably going to fall under the professional service exclusion. And here the opposite was found below, is that this just isn't a medical negligence case that would go under Chapter 766. So again, for all of these reasons, the policy is to be construed in pediatrics' favor, not in Wausau's favor, and we would submit that there is coverage and at the very least a duty to defend based on the allegations below. And we would ask that your honors reverse the trial court's judgment. Thank you.
All right, thank you both. Well argued. The timing was impeccable, by the way. We're going to stand in a short recess, maybe 10 minutes. So we'll be in 10-minute recess, and then we'll take the last case, which I believe is USF and Rousey.